Welcome, everybody. Welcome to another episode of the Wednesday webinar with the Property Law Alliance. It's a pleasure to have you all with us. Bruno, Silna, always a pleasure to have you guys with us. How are you guys doing, Silna?
Very good, thank you. Happy St. Patrick's Day.
Usually I have a theme to this, and I don't know if I can do a lock of the Irish. A lock of the Irish.
I think it was
Bruno,
close.
how are you doing?
I'm all right, thanks. How are you doing?
Good. Sorry, Silna, I interrupted you. You were still about to tell me how well you are.
Oh, I'm very well, thanks. Not as well as your Irish accent, though.
Oh, it's good to have you all with us. It's a little bit of an overcast day in Johannesburg. Silna, does it look the same there where you are?
It's treurig. And the scary thing is I'm moving tomorrow and Friday. And I really need everybody to focus on the weather for me and send me, all the sunshine and dry, moving friendly weather for this weekend. Moving is terrible as it is. If everything is then wet as well, it's slightly unpleasant.
Yeah, fair enough.
Oh, guys, I think let's get straight into this episode that we have. We have some very interesting neighbor law questions lined up. And the first question that we have is around a boundary wall. The question goes, there's a boundary wall that collapses, and my neighbor refuses to go 50-50 for the repair of this boundary wall. Can I pay for the repair and then later demand that he pays the 50% that I deem, that it's his share and that he needs to pay? So I think let's throw this one to Silna, and then we'll go to Bruno.
So, Bruno, I actually think this is more your question, but I'll give my 5.5 cents and then I'll pass it back to you.
5.5, sure.
I'm not specific ever. So, the thing is, because neighbor law is so I'll give the background again. I'm the background one every time. Our neighbor law is the majority of our labor law is neighbor law, is pretty much straight Roman law. It's very old, very well-established legal principles, but it comes from Roman law. There's a little bit here and there on neighbor law that touches into Dutch law, majority Roman law. So why this is relevant is the way property ownership worked and the way societies worked way back when the law was established, the Roman law now specifically. Life was different. People couldn't name and shame each other on social media and say like, I had to put up a boundary wall and this guy didn't even pay me. They didn't have that. So they had a very high sense of what is reasonable and how a society, remember, there were much less people as well at the time. So people weren't, there was a much stronger sense of government or authority, and almost all the people that weren't the Caesar, weren't a king, were like peasants. All the peasants were the same. So land ownership wasn't as well recorded and well established as we are currently seeing, not just in South African law, but law across the world. So neighbor law comes from Roman law, which is so it's a common law thing. And we have a lot of cases. Some of the cases that we're going to refer to tonight quite often is, for instance, Holland versus Scott, which is a case from 1881. It's like flippin' lang terug, julle. It's really long ago. And the other one is Malherbe versus Ceres Municipality, which is from 1951. So why I'm mentioning this is neighbor law is different where we are now, because when you, for instance, have majority people living in sectional title schemes or other common living things, we have more legislation regulating it. We have rules regulating it. If you and I have our houses are next to each other, as much as we don't have conduct rules and stuff, still we have municipal bylaws and things like that that you didn't have in Roman law. So I think it's very important to know that there isn't an act that says this is how neighbor law. There isn't the Neighbor Law Act, for instance. It's a common law thing. And I always laugh. We've always had this joke way back when we started the firm. And the people always call you as an attorney and they say, but what does the law say about this? And you're always like, the law doesn't say much, actually. It's the way we interpret it and the way we apply it. And then there was always this joke about this attorney that gets the call and the prospective client asks, just tell me, what is the law about gates, like a driveway gate? And the attorney said, the rule is a gate must be black. And that's pretty much what I can say about neighbor law. A gate must be black. So just for our viewers, that's just a joke. It's not a rule. It's not a law. The reason why it's a funny joke is neighbor law is so up in the air. And it all centers around what is reasonable, what is fair, and what is the bylaws and the regulations in your specific area and your specific facts. So I haven't even touched the question yet. So when it comes to a collapsing boundary wall, the only thing that you're going to be left with is the common law and potential bylaws or conduct rules in your specific circumstances. And you can't try and negotiate with someone. And if it doesn't work out, you're just like, okay, what ifs? I'm going to proceed and build and then sue you for 50%. You can't, because you have no delictual right. There's that is neighbor law. And if you can't prove a right, you can't prove a claim. So I think I'll start us off on this answer like that. And now, after my 5.5 cents, okay, it was 5 cents and 3/4.
That was a lot there, Solna. I think you actually gave us R5.50.
Okay, so for my 5.5 cents.
Now you must give 10. You must give 10, Bruno.
10 cents or 10 Rand?
Don't be an unreasonable rebel now.
But yeah, so from a context perspective, Solna's absolutely right. Like neighbor law, and just in general, I mean, we look at a lot of property law elements that come all the way from Roman Dutch, and it's really complicated. And as law students, when we sit there, it's just it's small little elements. When this happens, this was the law, and this is what this guy wrote about, and he disagreed, and then this scholar said that they got it all wrong, and now we're mixing it up again, and it's just crazy because it keeps evolving. So a law today, tomorrow will be interpreted differently by a court. And in the past, there was such a level of specificity that that you tend to find that now reference to those type of regulations doesn't apply anymore, exactly for the reason that Solna mentioned, which was we've started codifying a lot of things. If you look at a lot of legislation in South Africa, for example, certain basic elements that we've always had in our laws, in common law. So common law is not something that's codified, or it's something that you'll find in case law through application over hundreds and hundreds of years, right? And it's just certain things that apply in general. Even some of the crimes that people get prosecuted nowadays aren't necessarily in a piece of legislation that say don't do this. They're just from common law, and lawyers are basically trained to understand these, to know their existence, and to be able to work around them. So neighbor law is very similar to that. However, as we progress the society, we find that the legislator loves taking these laws and codifying them. And in the codification, sometimes they even change them. So there's a whole concept of developing common law, basically means that law that no one's sure about except for lawyers, legislator has taken it and put it in paper and added their interpretation to it. And then when we go to court, we need to try and figure out what they meant by the laws that they actually put in this paper called legislation. So with neighbor law, it's Sectional Title Act, for example, or to Sectional Title Management Act, or Sectional Title Act, all these different types of acts that actually deal with how people are supposed to interact with each other. And that obviously governs, concepts or ideas like boundary walls and distance from boundary walls and disturbances. And these are all things that are legislated because, I mean, from a security perspective, for example, you're not supposed to build too close to a boundary wall. That's actually something now that's in most bylaws. It's because of considerations of safety and, fire moving from one premises to the other. There's a bunch of factors to that. So each area might have different laws. And if a bylaw comes out and says you have to have a wall that's X high, then that's the rule. If nothing's mentioned, then the question comes down to what happens in this specific question when it comes to this boundary wall. Now, if the boundary wall is contained in between, like right on top of both properties, and it's a shared wall between the two, one now needs to look at, for example, whether it's an act of God or whether it's somebody's fault. Because the act of God is a slightly different scenario because obviously it was no one's fault. So in these circumstances, one would typically, and again, it comes back down to whether there's other governing legislation, but one may typically say that both neighbors should contribute to the building of the wall. The wall existed, it was already there, it served its purpose, both neighbors were content with it, and something happens to them, both neighbors should actually put up the wall together and contribute to each, contribute 50-50. If it's one neighbor's fault over the other, it's a different story. Because if, for example, one neighbor drives their car into the wall and it collapses, then they are responsible for 100%.
And it happens way more often, way more often than I think our viewers might be aware of.
Yes, no, it really does.
So if your neighbor runs a cult and considers himself God and then bumps the wall, is that an act of God? Forget that. Let's just go back to what you're saying.
Well, I wanna add to your act of God. I actually want to say happy anniversary to everybody for yesterday. Was exactly a year since our national state of disaster was declared. And remember, last year this time, the amount of calls we had to deal with around vis major being an act of God and causa fortuitus and all those fun things. So with the moment you said act of God, I thought, yay, happy anniversary, COVID.
Nice.
I just did. I had to. Okay, carry on, Bruno. I'll be serious again and keep
going. No, it's fine. I think that's pretty much it. So I suppose the only other example I can think of outside of fault is, for example, walls that are found on land that's subject to a servitude. Because in those instances, you typically tend to find that the servitude is registered in favor of somebody else, but the person owning the land does still need to maintain that land, especially for the maintenance of the servitude. But maybe that's you don't typically find that all that often, but in situations like that, for example, the owner of the land would be responsible for maintenance in order to sustain that servitude.
I actually think it's a very valid example, Bruno. I think you make a much more valid point than I think you even seeing there. Let's take a urban situation with what do you call it? A pipe steel out, a pipe panhandle.
Panhandle, yeah.
Yes. Pipe steel. Yes, I am impressed that you got that one. Well done. If you have a panhandle type situation and it's a servitude, the holder of the servitude could very well be the party responsible for maintenance of the wall, if that is what the servitude stipulates. So I think, to your point, if you have an earth and you are the subservient earth, or for that matter, you are the holder of the servitude, just make sure that you ask your conveyancer to draw the full servitude document from the deeds office, so you know exactly what it says. Because I think we spent basically a year on a candidate attorney to train them not to make any assumptions in law. And I think, to the benefit of our viewers, never assume something in law, because a servitude might be registered, and it compels the holder of the servitude to be responsible for the maintenance of the wall. And you can't then go back to the subservient earth owner and be like, okay, come fix my wall. It's not a you problem. And I think that's what Bruno and I were discussing now before we started as well. You can't have a one-size-fits-all answer when it comes to neighbor law, because the area, the specifics of the earth, the specifics of the thing that we're fighting about is going to be different from one case to the next.
No, thanks, Solna. Thanks, Bruno. So we'll move on quickly to the next question, which is very similar, well, on the same theme. Today's theme is neighbor law. And this question is quite an interesting one, because my neighbor actually has a peach tree, and I'm going to go into the question. So the question is, if a fruit tree is growing in my neighbor's yard and that fruit from that tree is hanging over into my yard, am I able to pick this fruit? Am I entitled to it? Or if I pick it, is that then considered theft? Now, please give me a good answer here, because my neighbor has the most succulent peaches that grows off his tree. And there's a lot of them on my side. So I'm thinking about actually starting a little peach jam business. So please, somebody, some good advice here.
I must say, I'm glad that you used the example of peaches, because this might be a fact that not a lot of people know. But I actually grew up on a peach farm. I was also, wait for it, on the cover of the Landbou Weekblad in a peach tree in my day. In October 1991. So peaches, hit me with the peaches. I can answer peach questions. Who is answering? Okay. Am I answering?
You can go for it, Solna.
Well, I took it anyway. just because
well, man could say no after that. It's like, okay, well, she was on the cover of a magazine.
Not just any magazine, Bruno. The Landbou Weekblad. I mean,
I can't pronounce that, so it's.
You didn't know I was a cover model, right?
You're a celebrity. Wow.
I'll one day, if you ask nicely, I'll show you a photo.
Oh, you have to. No, you have to.
Okay, so the answer on the fruits is fruit belongs to the tree, and the tree belongs to the owner of the land where the tree stands. So the principle, I've trained the entire day. One of our senior associates, Claire, actually came to me with the Latin term here, and I've been practicing it all day, so I can't wait to use it. It is, the principle here is fructus pendentes pars fundi vindetur, which means fruit, hanging fruit, forms part of the land. So here's a fun story. I've actually studied this today. Thanks, guys, for the questions. You make us study stuff again that we don't usually deal with. But the answer lies on if you have, let's take your peach now. Your peach is still attached to the tree. It's hanging over your wall, but it's attached to the tree. The fruit belongs to the tree, and the tree belongs to the owner of the land where the roots are in. So it belongs to your neighbor. You can't pick it. The moment the fruit falls, from the moment the peach leaves the tree until it hits the ground. That was, did you hear my amazing land?
Yes.
That's how you know
effects.
I'm
Love
an expert. For that time period, it is deemed to be res aliena, which means it doesn't belong to anybody. But I mean, that's split second. So if you accidentally swoop in and pick it, then catch it, not pick it, catch it, then cool, you can do it. But the moment it hits the ground, it becomes the property of the person who owns the land. So then you can have it. If you have to prune a tree that's lying over your wall, you may prune, but you need to make sure that you don't accidentally prune to the point where the tree is going to fall over. So because that would be a delictual problem. But if you prune, the branches that you've cut off still belongs to the owner of the land where the roots are. So in strict theory, you can prune, but then you have to gather the branches and walk to the neighbor, ring the bell. Hello, here's your branches, which I must say, it's when you look at that, that's why I started off by explaining this is very old Roman law. In today's day and age, you're going to get a tree feller, and the biggest thing you're going to ask is, will you also remove the branches? And the truth is, if you go to Umkali, your neighbor, and you ask the tree feller to drop off the branches on his front stoop, Umkali is not going to be a happy camper, and he is going to really make sure that anything else you do is going to, he's going to report it. So, but that's the rule in law. So if you have to prune and there are fruits on it, you need to return the branches with the fruit. So you can't say, "Ooh, this is an amazing peach tree. It looks amazing," or avos. I hope my dad's not watching. Excuse, Papa. But avos are amazing. So if it's an avo, I didn't say I'll pick an avo over a peach. I'm just saying if my dad is watching. But if your avos are hanging over the, you can't say I had to prune and in the process collect all the avos. If you prune and they fall because of the pruning, it's similar to the branch that now still belongs to the owner of the land where the roots are set. I cannot believe this is the answer I am giving.
Nice. So I can't start my peach business. This is what you're saying.
Yes. But I can give you my dad's number and you can buy peach trees from him, definitely.
Or you can wait for the peaches to fall.
Yes.
But remember, by the time a peach falls.
Yeah, it's
fraught.
You can help it along without anyone knowing.
Take a broom. I'm just dusting the leaves.
I'm cleaning.
So for the sake of context, it's a very interesting area of law, because I can imagine a lot of people watching going, like, who seriously has this problem? Like about gathering fruit and branches but the funny thing is, this area of law actually extends back. The use of the word fruits, just to begin with, isn't necessarily actually just fruit, like literal fruit. We're speaking about a lot of things that are derived from neighbors' lands, or items or assets on neighbors' lands that actually generate fruit. So these things played big roles, for example, when it came to farming, when it came to livestock, like calves, newborn calves, who do they belong to? Harvests that went over boundaries, who do they belong to? Trees that used to grow in a certain way, and even other things. So it wasn't just that. I mean, at a stage, things like rentals were also considered under this. So when people, for example, mortgaged properties, the fruits from that property being rentals, who do they belong to? The reality is, nowadays, a lot of the stuff is properly governed. So in mortgages and agreements and National Credit Act and all the like, it does deal exactly with what the mortgagee is entitled to have and not entitled to have. But so the fruit example is always just how we studied it and understood it, because we actually thought of peaches or avos or whatever you want to think of. But the truth is, it's things that it's some benefits that's derived from that land that can be considered fruits. And what's interesting, so I was also reading through this. So and I mean, like Silna got it spot on. The bottom line is, if it's on the tree and you go and you try to cut it down, you're technically interfering with somebody else's ownership, and that's not right. And and obviously, in the bigger scheme of things, not the one peach from your neighbor's tree. I don't think anyone's going to complain about that. And the general rule was always that the ownership always followed the ownership of the principal item. So if that item belonged to one person and fruits were derived from it, the ownership of the fruits belonged to that person. unless, and that's where certain examples existed, things like if you're a bona fide possessor, it was okay. If you were a tenant, it's okay. If you were a mortgagee, it's okay. And that's typically how this law derives. So people are entitled to the fruit of their asset, and unless obviously the right to that fruit was somehow appropriated by somebody else. And if those people collect the fruits, then it belongs to them. But yeah, so it is very interesting because it's not as applicable nowadays as it was in the past. But it is still one of those very theoretical areas of law that it's very difficult to actually apply and remember.
No, thanks for that, Bruno. Thanks, Solna, for this information and also for breaking my heart, my poor peach business. Look, let's just move on to the next question, right? Which is also around neighbor law. Now, this one's also very interesting because it involves elements of what we're going through now, or what we went through with lockdown and working from home and the like. The question is, well, it rather states, I live in a complex with a sectional title scheme, and both my neighbor and myself have been working from home. And this, of course, due to COVID-19. My neighbor's job requires him to be on the phone all the time, even at odd hours of the evening. Unfortunately, I can hear every detail of every conversation that he has, and it really disturbs me. Now, I understand that noise is a factor to consider when buying in schemes such as the one that we live in. But is there anything I can do to get him to stop? Because it really is becoming a bit much. So I think, Bruno, if you want to throw us your advice here on this one, and then we'll move to Sona.
So the funny thing with noise is this is pretty much the most common type of issue that people typically find. Noise is a big one. I mean, I've had cases, for example, but the industrial areas of sawdust going to one property to the other. But the reality is, if a person's sitting next door a couple of spaces away and there's loud noises, it's terrible. And it becomes such a fight because noise is also something that's so difficult to actually approve or work with or try and fight against. So there's there's a concept of disturbing noise versus noise nuisance. And the difference obviously being that disturbing noise are things that just outright are disturbing. So either certain decibel levels have been set and these can be enforced. So extremely loud music, extremely loud parties, actual disturbing noise. And this is something that can be very, very easily stopped because it goes beyond reason. It's something that you could even call the police over. There's, there's probably bylaw infringements there. And then you have things like noise nuisance. Now, this is somewhat difficult because this is basically just in the scope of your civil law where you're discussing whether something impairs your enjoyment over the property. And so, for example, you can hear the dogs barking in the background, right? Can anyone hear that?
No,
Okay.
Bruno, not at all.
Yes, you can. Are those your dogs?
No, not at all, because I can, and I can barely hear myself think. And those are my neighbor's dogs, right? So by that very token, it could be very easy for me to argue and say, well, it's impeding or hampering my ability to do work. I'm at home. I should be able to work from home. The neighbor's dogs are barking. This is utterly unfair. They should know, I've got property law alliance at 6 o'clock every Wednesday, but they keep on barking. And it comes down to reason, because at the end of the day, the poor dog doesn't know that I have property law alliance every Wednesday at 6 o'clock.
Why aren't they watching?
Maybe the neighbors know, but not them. And so that's the thing. How unreasonable is it? A person speaking, and we actually had, like, it's an interesting discussion. So I'm just thinking now, if I was speaking at 2 o'clock in the morning and I was working and I was speaking loud enough for somebody next door to me with a shared wall or right across the wall and they can hear everything, that I would say is unreasonable because it gets to the point where it's very disturbing. However, again, it comes back down to reason. Like, how bad is it? This person's job, it's his own private property. He's entitled to be on the phone if he needs to be on the phone. So we need to look at this from the perspective of what is reasonable, what isn't reasonable. Does he have to work at that time in the evening? Is there another choice? Because if there is, and he's just opting to do these things at that time in the evening, it's arguably not okay. But if he doesn't have a choice, and he's taking all precautions, and it's still unfortunately disturbing, it's very difficult to stop him, because what can you do? And it's about balancing rights. It's the same concept that we have with our constitution, where it's not about him just having the right and you having none. It is a question of balancing, going, well, you have the right to sleep and privacy. You've got the right to do your job. In these circumstances, how can we balance this in the best way possible? And I think the answer, so there isn't any right or wrong answer. I think it is just a question of somebody having to make the decision on what actually works out best.
I agree with that, and I think what's crucial is exactly, and this is from the two cases we referred to earlier as well. Neighbor law comes down to reasonableness. What is reasonable? And for instance, say the guy on the phone, depending on the kind of job he does, it's like, for me, I'm on the phone the majority of the day, and I do prefer to walk around when I'm on the phone, and I do prefer to be outside. And I'm quite sure it irritates my neighbors a little. Well, not for long, guys. I'm moving tomorrow, so but it might have bothered people a little. Now I'm just going to irritate my boyfriend's phone, but it could be a problem, and it could be but I cannot not do my job. I can stay inside, but it comes down to something. Say a neighbor has a baby, and the baby has colic. The baby, unlike work, isn't going to stop. Like, the baby doesn't care if it's 3 a.m. The mum would also love the baby not to cry. And we've all had that. We've all seen that. And I think that is where you make the choice between communal living and not. If you can't handle any form of noise, then the recommendation would be go live on a farm, or a farm sort of estate where you have big earths. And if the argument is then, but I can't afford that, okay, now we need to work with what we have. We would all have to, exclusively live off Woolies pre-cooked meals, but still we need to sometimes make a call between what I want, what is practical, and what you can expect from another person. And I think that's sort of the point. People have this weird sense of entitlement, and it's more so now than I think ever before. And I was hopeful exactly a year ago that COVID and the shared trauma we have from it made people a little kinder, but unfortunately, as far as I can see, it had a very opposite effect. People are even more entitled, and even more selfish, and even more self-righteous, which is unfortunate. And that is what we want to see change in the law, because I don't know about you, but the amount of matters I see that people want to push to court just to prove a point is actually more now than what I've seen before. And I think, unfortunately, people don't really appreciate the level of PTSD that we all suffered through last year, and they sort of taking it out on each other. So I think the answer is just go and sit down quickly and appreciate that the other person is as human as you are.
So we need to count our blessings. And also it would help if your neighbor in this particular question was a stockbroker and was discussing stock market deals, and you heard every bit of that conversation: buy now, buy low, sell high.
At least they're not eviction lawyers, because that could be considered traumatic. So they not understand, and it would be a nuisance if we were speaking on the other side of a wall at 2 a.m.
Luckily, eviction lawyers don't easily talk to anybody at 2 a.m.
Yeah, fair enough. But was something interesting that Silma mentioned. So I've been doing mediations now, I think since 2010, 2011. I was trained as a mediator, and I've been doing it. Like, I love the idea of mediations. And there's a huge psychological component, because it's not simply making a decision and saying, well, you're right, you're wrong. It's about actually trying to persuade both parties to come somewhere in the middle and to start, it's intuitive, or start seeing some kind of logic or a rationale for why they're doing the things that they're doing. And maybe just for the viewers that are watching this, specifically for answers on how to fight their neighbors. Look, I know better than anyone. There's some neighbors that are just, there's no reasoning with, right? As much as you want to try, it just seems like there's a brick wall and nothing makes sense. But there's other neighbors where you can get through. And I mean, even like Silna, surely you've had this. I mean, we've gone up against opposing attorneys and opposing counsel that you're trying to figure out where the reasoning is for certain demeanor. I mean, it's not logical. It's not giving them an advantage. It's not doing anything. For all intents and purposes, they're probably going to land up losing the case. But it's like constantly hitting a brick wall where you can't get any logic through. And there has to be underlying reason, and that's the reality. Is there's always a psychological reason. And if you can get people into a room together to start having that discussion, it's possible that it'll actually come out. It's not guaranteed, but it's possible. And you may find that at some point there's crossed wires, there's some principled argument where one person dislikes the other because one time they parked on the grass outside of their property and they found it completely disrespectful. There's the stupidest arguments. The reality is, maybe get someone independent even, just have someone listening and looking at this. Because the one thing I know is, even if you're not trained as a mediator, having a third party sitting and listening to a stupid conversation is probably going to get a result, because no one wants to look stupid. So by the time it gets to that, they're going to very quickly start trying to sound logical, and they're going to concede and capitulate a lot easier, and that's going to bring a solution to the problem. So if you're going to take anything out of this, maybe knock on your neighbor's door with somebody that's relatively impartial and start having that conversation in front of this person, even if it is just for the sake of bringing some kind of closure.
I agree with that, because people tend to run to a lawyer first. And I promise you, if you're already in an unfortunate situation, to throw a lawyer into that equation with the wrong attitude and the wrong idea, and with, and I'm sorry, I say this with, the necessary collegialness.
Respect.
I won't go that far, not on what I'm about to say. But if you accidentally end up with an attorney that would push you on litigation just to write fees, it might not resolve the problem. It might make it much worse.
Oh, absolutely. Yeah.
So don't go into a fight unless you're really, really, really sure that you are up for the trauma of litigation, and you have to walk past this neighbor every day to get your car, whatever. It's awkward. This is where you live. This is your den. This is where you should be safe and not have emotional stress. Try to avoid that by rather, a cup of tea goes a very, very long way.
So true.
No, that's very true, guys. And I actually now just read a quote that said, a good neighbor increases the value of your property. So maintain those relationships. And yeah, this is our episode on neighbor law. It was quite interesting. I myself did not know that it was so complex in that sense. I thought we just didn't speak to your neighbor and that would be it. And yeah, no peaches for me, none of it. But thank you so much, guys. I really do appreciate the advice that you've both given us and the effort you've put into this the session. I hope that the viewers have also found it quite informative, which it definitely has been. So yeah, thank you so much. I hope to see you all next week. Please remember, post your questions in the group. We have lots of space for it, and we'll definitely be getting in getting down to the questions that have been asked yesterday and the day before. So please continue to ask those questions, and yeah, we'll see you all next week at 6 o'clock. Thank you, Bruno. Thank you, Silna.
Thanks,
Cheers, Chris. Cheers, guys.
Bye-bye.